What's up, everybody? It's Peter Tragos, the lawyer you know, and today we are going to answer the main question everyone has been having as they watch the Nikolas Cruz penalty phase trial for the Stoneman Douglas shooting case going on in South Florida right now.
Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have.
So I brought my dad in, Big George, here to talk about a criminal case that's happening here in our home state of Florida, down in South Florida. Nikolas Cruz, the Stoneman Douglas shooter, is on trial, but only for the penalty phase. He has already pled guilty to multiple counts of murder and other charges, and he faces either life or death in prison because in Florida, we have the death penalty, and that penalty phase is what's happening now on trial in front of a jury with public defenders defending Nikolas Cruz and prosecutors prosecuting the case for the state. And everybody has virtually had the same question. Comments about how difficult it's been to watch and listen to this trial have been a common theme throughout. But everybody is wondering, why are the defense attorneys objecting? Why are they fighting these pictures and these videos and the things that our prosecutors are trying to enter into this case? He's already pled guilty. He's already admitted doing these things. So why not just let it happen? Why not just let this evidence in? It's not like this evidence is inauthentic. It's not like this is a fake video that's been doctored. So why are they objecting? Why are they trying to stand in front of this? So Dad, as we answer that question, let's first set the scene as to what the defense has actually done to try to block some of this evidence from coming in during this penalty phase trial.
Well, the judge and the rules require that the prosecutor gives them whatever it is they're going to introduce during the penalty phase. And they gave them the list of videos they're going to put in. At that point, they filed what's known as a motion in limine, which means a motion to limit what the jury would see or to stop what the jury would see because it's so outrageous or prejudicial that the jury shouldn't see it. And so they filed the motion in limine, and they had a hearing before they even selected this jury for the judge to rule on whether or not these were going to come in.
And if you remember from like the Johnny Depp case or the Kyle Rittenhouse case, every case before trial there's a motion in limine. We file one before every one of our cases because certain evidence cannot come in for a multitude of different reasons, because the rules of evidence in trial do not allow certain statements, pieces, pictures, videos to come into evidence because they're inauthentic, because they're unreliable, or in this case, as you explained, the defense thinks it's going to inflame the jury, and there are also some other arguments that they've been making throughout trial as well, right?
Right. Well, because he pled guilty, the reliability of these videos aren't in question. These are real videos, and they're real videos that accurately portray what did happen that day. But the idea or the argument is their prejudicial value outweighs the probative value, which means it's going to be so prejudiced to play these that it really outweighs whatever benefit factually these videos are going to present. And I think that argument's obvious. You see something on video, it has a much greater emotional impact on you than if you have somebody tell about it. And that's all. In fact, the prosecution specifically said, the defense specifically said, we only want people to tell about it. We don't want to show the videos. And for obvious reasons, again, they're arguing for him to get a life sentence without parole and not the death penalty. So that's why they're trying very hard to make the emotions as low as possible in the courtroom.
So I think it's important to point out as well that a lot of you are asking this question because they've already admitted guilt. And the defense is actually using that to try to limit the evidence because the prosecutors do not have to prove that Nikolas Cruz did this. They do not have to prove where he went or what he did or who he killed because that has already been admitted. So they're saying, why play these videos when we've already admitted that he did all of these things? And the prosecutors have their reason because they are trying to prove aggravating factors. They're trying to prove how deplorable this action was by this defendant as to why it necessitates a death penalty. But throughout the trial, what has the defense done? While this evidence that the judge ruled against them in the motion in limine, the judge has allowed the tapes and the pictures to be able to come in, and they've played a lot of the audio and the video and the pictures throughout this trial. But what is the defense doing throughout the trial?
Well, during the penalty phase that they're arguing about, the defense has argued every single video. So before every video, they stand up, Judge, we want to object. We have a sidebar. That stops everything. Everybody walks up to the side of the judge's table or bench, and they argue it out of the presence of the jury if the jury can't hear it. Well, that breaks up the continuity of the trial. If you think about it, you have that delay, goes on over and over again. And the judge just recently said, look, I don't care. You don't need to do this anymore. You can have a standard objection. I promise you, I will deny it every time. And their new objection is it's now cumulative. So it's not only is it prejudicial to bring that in, but now it's cumulative, which means, Judge, why do we have to go over and over again showing one video after the other to this jury? You really don't need to do that. The state's argument is, Judge, these videos show different victims. They show different angles. They show different locations in the school. And as these videos are played, the audience is not able to actually see the videos. They're only able to hear them. Only the jury can actually see the videos. But the hearing is so dramatic that you had a parent stand up during the middle of this and scream, stop it, turn it off. To which the defense moved for a mistrial because, again, that emotional reaction, they don't want that. And the judge denied that mistrial and had it go forward.
And I think it's important to point out as well that these arguments, these evidentiary arguments, are arguments that the defense needs to make to preserve the issue for appeal, because there will be appeals. Especially if he gets the death penalty, there's automatic appeals. So this case will get appealed. This penalty phase trial will get appealed. So they're preserving those objections and those arguments for appeal. So the judge has said we can have a standing objection basically for every piece of evidence that comes in, every picture, every video. We know you're going to object more prejudicial than probative. We know you're going to object now that it's cumulative because it's been played over and over again. Denied, denied, denied. Let's get through this trial and you can deal with the issue on appeal if the trial judge is making the incorrect decision. So the question now is, so we know what they're doing. Why do you think the defense is doing this? Why are they standing up? Why are they objecting? Why are they making the same argument over and over again, knowing that they're going to lose?
Because they want to give the jury time to calm down maybe after every video, to lessen the emotional impact of the video, to try to get this jury to look at this coldly. And I mean, you've got jurors already that are almost crying up there as they're watching the videos. They're looking at Mr. Cruz saying, what kind of reaction is this kid giving while these videos are playing? So there's no way to know. We can only speculate. You know what the hearts of these jurors are going to be as they listen to these videos and what it's going to be like. So, it's going to be very difficult, I think, for them to get a life sentence. The defense lawyers are arguing you've got 17 capital murder charges. You have 17 attempted murder charges. There are 34 separate victims. It's going to be very difficult for them to just get a life sentence with all this evidence and all this emotion behind this case. Because
one of the aggravating factors is not just that he had a reckless disregard for human life, but also that he did it over and over and over and over again. And he went back to certain victims that weren't dead to make sure and to shoot them again. I mean, the facts are about the worst that you can think of, but it's also important to think that the defense lawyers have a job to do. They're protecting the record from appeal. They may be breaking up some continuity in the prosecutor's case. They're trying to mitigate the aggravating factors of this case, and they're trying to get their client a life sentence versus a death sentence. That's why they're making these objections, because they're trying to keep from inflaming the jury to making them really hate their client, wanting to give him the death penalty.
Well, another factor for the death penalty is planning. And there is actually a video that was made of Mr. Cruz before this happened, where Mr. Cruz said he wanted to do something like this. So that's going to be a tremendous aggravating factor for the prosecution to argue when they see the video of him actually saying he wants to do an act just like this.
And basically, the fact that he's pled to this and admitted these charges, the only argument you're not going to hear from the defense is that he didn't do it. They're not going to argue he didn't do it, and they're not going to argue that he was insane at the time of doing it legally, to which he needed to be not guilty by reason of insanity. You're not going to hear those two arguments. Just about anything else is fair game as they represent their client in this penalty phase. Do you think the judge made the right decision in allowing the videos and the pictures in?
Absolutely. I mean, there's just no way to keep them out. I think they absolutely made the right decision. The defense absolutely did the right thing trying to keep them out. But when the dust settles, this is evidence. It's admissible evidence. They had the young people who actually took the video. They testified during the trial when they showed their video, and they testified, I took this video, where I took it, how I took it. Very dramatic. But the key, I think, to the defense is going to be mental state. I think that's what they're going to argue to this jury, is that he was, kind of a mentally not really there, didn't really know what he was doing.
Abusive childhood.
Not really, an insanity defense, but an offense that does enough mitigation to make the jury feel sorry for his mental state so that they give him the life sentence.
The last penalty phase trial we discussed here in Florida was the Ronnie O'Neal trial, and it was the same thing. His childhood, he was abused, he had a rough childhood, he was maybe had some mental issues, mental health issues that came up throughout his childhood to help him make these bad decisions. And because of that, we're not saying he's not guilty, we're not saying send him home, we're just saying send him to prison for life as opposed to ending his life. That's what the defense lawyers are basically going to argue. Just a couple weeks in, what's your prediction for the verdict?
I think it's a death penalty.
I agree, although I did think Ronnie O'Neal would be a death penalty as well, and it was not. So we think it's going to be a death penalty at this point. We'll keep updating this case. If you guys are interested in it, let me know in the comments if you're interested in it. Let me know in the comments if you have any other questions regarding the Nikolas Cruz trial. And if you have the interest, we'll keep doing update videos and letting you know if our prediction changes as this 4-month penalty phase trial continues. But for now, that's all we've got. Thanks for being with us.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.